All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Angus House presiding, is now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have 4 cases set for argument today, and as you will see, Judge Kinsley is going to be appearing on the screen by Zoom. So for those of you arguing, just keep that in mind so that if she has any questions, you'll pay attention to the screen as well. I'm going to go through the cases that we have set, and if the parties or lawyers arguing could please state their appearance and their readiness to proceed, I would appreciate that. The first case set for argument is C-240719, and we have Kofi Ajapong versus Edelman Holdings, LLC.
David Donnet on behalf of Edelman Holdings.
Kofi Ajapong, appellant appearing pro se.
Okay, thank you. The next case we have for argument is case number C-240664, State of Ohio versus Libya Saunders.
David Hoffman for the appellant, Your Honor, ready to proceed.
For the state, Your Honor, ready to proceed.
Great. The third case set for argument is C-240463, State of Ohio versus Nolan Garrett.
Josh Thompson on behalf of Mr. Garrett, ready to proceed. From the state of Ohio, Your Honor, ready to proceed.
Great. And the final case is C-250106, State of Ohio versus Kathy Howell.
Jason McGarry on behalf of the state, ready to proceed, Your Honor.
Okay.
Laura Peters on behalf of Kathy Howell, ready to proceed.
Okay. All right. Well, we will start out with the Ajapong versus Edelman Holdings. If the parties would come forward, please. Mr. Ajapong, you have 15 minutes to argue, and you can reserve some time for rebuttal. Would you like to reserve some time?
Yes, sir.
How much?
I'd like to reserve 3 minutes.
3 minutes. I'll keep your time. You have lights on your podium. When there's a minute left of your initial time, the yellow, I'll hit the yellow light, and when you're finished with your initial time, the red light will come on. Okay?
Thank you.
Whenever you're ready.
May it please the court, my name is Kofi Ajapong, and I'm the plaintiff appellant appearing pro se in this matter. The question before the court today is whether a landlord who fails to return a tenant security deposit within the 30-day deadline under the Ohio Revised Code 5321.16b can avoid the mandatory provision statute in 5321.16c by eventually returning the deposit 17 days after the 30-day deadline has passed. And I respectfully request a reversal of the trial court's ruling and entry of judgment awarding double damages as required by law. So RC 5321.16 is unequivocal in its statement that subsection B requires that landlords return a tenant security deposit within 30 days of lease termination. And subsection C mandates that if a landlord fails to comply with that timeline, the tenant is entitled to damages equal to the amount wrongfully withheld.
So in this case, you're saying it's the whole $600?
Yes,
And so the penalty you seek is really essentially $1,200?
yes.
And what do you think the intent of the legislature was, or when they passed this law?
I believe that the intent of the legislature was to ensure that landlords could not arbitrarily hold on to security deposits after the 30-day deadline had passed, and to ensure that tenants could be availed speedily or with all requisite speed of the security deposit that they're entitled to.
And in your case, it's my understanding it was something like a 17-day delay?
Yes, Your Honor.
But in essence, you're saying it's a species of what we call strict liability?
Yes, exactly, Your Honor.
Go ahead.
The trial court made significant issue of the forwarding address and raised questions as to whether or not a forwarding address was submitted, and went as far as to suggest that the forwarding address and a lack of submission could essentially eschew the landlord from the strict liability mandatory provision. And I submit before the court that there isn't any precedent, for that conclusion in existing case law. And I would refer to both Prescott v. Mikowski and Adams v. Davenport, which, when taken together, underline the strict liability nature of the rule and contain language that make it clear that actual knowledge is the main requirement as to where the tenant is actual knowledge is required for returning the deposit, and not necessarily a physical forwarding address, and that any attempts to nullify liability via the technicality that exists in claiming that the tenant hasn't effectively provided a forwarding address can't be used to allow the landlord to return or can't be used to excuse their double damages liability under the statute.
Sir, I understand the steps here can be complicated, but I also want to make sure that I understand what happened in the trial court below. So it's my understanding that the decision here was reached by the magistrate initially. Did you then file an objection for the trial court to rule on, or did the trial court just rubber stamp what happened with the magistrate? Can you address that?
So, Your Honor, as a pro se litigant, I will admit that I'm not entirely conversant in the process in the aftermath of the decision that the magistrate reached. All I know is that I stated my intent to appeal and appealed to the district court as soon as I was able to effectively do so. I believe that it amounted to a rubber stamping of the magistrate's decision, but I can't definitively state whether or not that is the case.
You represented yourself below,
Yes, Your Honor.
and you never appeared in front of the actual trial judge. You appeared in front of a magistrate.
Yes, Your
So you
Honor.
never had a hearing on anything in front of the actual trial judge who signed the final order that you appealed?
No, I did not.
So you're not, are you not aware, though, that our standard of review is different if you don't object to the magistrate decision?
I am not. I was not aware
Okay.
of that.
But you got a copy of the magistrate's decision?
Yes.
So typically on the magistrate's decision, there's some instructions that you have to object. Do you remember reading that or seeing that?
I can't say that I do. No, Your Honor.
Okay.
The appellee did make mention of a waiver, and I believe that it was in regards to the issues that have just now been raised. So I will just say that under Haygood v. Gale, a party does not waive their appeal rights by accepting an undisputed portion of a judgment if the acceptance is not inconsistent with the claim on appeal. And since I'm not challenging the $600 itself, I'm challenging the denial of statutory double damages due to clear noncompliance. I don't believe that a waiver, it's not my understanding that a waiver has taken place.
I don't think that they're arguing, and they can speak for themselves. They're not arguing that you've waived your appellate rights. I think what I was trying to tell you is that our review of the trial court, our standard of review is under a plain error standard, which is a very deferential standard of review. And what I haven't seen is you arguing to us plain error, how there was plain error below. So that it doesn't waive your appeal rights, it just kind of changes the way we can look at the case.
Okay,
Yeah.
okay. Thank you for clarifying. I will say in closing that to allow this trial court ruling to stand would effectively gut the enforcement mechanism of RC 5321.16. It would teach landlords that they can ignore the 30-day deadline, make tenants wait in limbo, and return deposits just in time for court while avoiding all the consequences. And that is not what the legislature intended. This statute is a statute intended to protect consumers or tenants, and it has teeth for a reason. I respectfully request that the court reverse the trial court's ruling and enter judgment awarding double damages pursuant to RC 5321.16. I will now yield my time.
All right.
Thank you.
You have about 6 minutes, 6.5 minutes. I'll save your time for you.
If it pleases the court, I think the court centered in on the issue of whether or not the appellant, he chose to ignore the rules and go straight to the Court of Appeals. The judge who reviewed the case without objections affirmed the decision of the magistrate. He's never argued that that particular judge abused its discretion. He didn't follow the rules. But this is a security deposit case, and the courts are all over the place, but I would point out that I don't think there's any more strict liability of 5321.16. And the important case for that is the Vardaman versus Llewellyn case, which I've cited in a brief, 17 Ohio State 3rd 24.
So, Mr. Dunnett, regardless of the procedure, you'd say on the substance, there was no damage.
There was no damage, which
So-
is what the magistrate found.
So, but setting aside the procedural problem that the appellant has, on the substance, don't you agree that the intention of the legislature is to provide double damages to incentivize landlords to get the security deposit back as soon as possible?
Yes, but Vardaman versus Llewellyn, particularly, what's interesting about that case is it basically says that if the landlord does nothing and 3 months down the line, after the 30 days have expired, and the tenant sues for the deposit, the landlord has the ability to raise affirmative defenses as to damages that exceed the security deposit.
But that didn't happen in this case. There was no, like, you owe me money and I'm subtracting it from the security deposit. It was, here is your entire security deposit back.
Correct.
So in that circumstance, wouldn't the damages be substantively doubled? The damages would be, you didn't return my security deposit, therefore I get $1,200.
No, the damages are twice the amount wrongfully withheld. There's also the
Well,
issue,
wasn't the $600 wrongfully withheld for 17 days?
again, no, he was given this, he was given the $600. So.
He was
as-
given, but he was given the $600 after the 30 days had passed.
Correct.
And he said, no, I don't want it, because he wanted $1,200.
Well, but again, there are two issues. One is, there's no indication that the landlord ever had a forwarding address until he filed the small claims complaint.
So, as to the forwarding address, how old is the statute?
If it's not been modified, it probably goes back to 1972, somewhere
So,
around there.
at that point, a landlord would need an actual physical address to send by the U.S. Post or some form of delivery.
Correct,
And now, people behave electronically, right?
correct.
That's what happened in this case.
Well, again, My client indicated that they didn't have a forwarding address.
But he was paying through the same app he was always paying his rent through, right?
Correct.
You could have just sent him $600 in the same app.
Well, again, they didn't do that. The magistrate, I think, correctly ruled nothing was wrongfully withheld. And that's the key to the statute, is what was wrongfully withheld. The statute is no longer automatic double damages.
So just so I understand, you're saying that if the security deposit is returned late, then that doesn't mean anything was wrongfully withheld?
Correct. And that's what the magistrate
So
said.
the timeline in the statute means nothing now?
Under Vardaman and Llewellyn, it doesn't. In fact, if you look at that case and look at the dissent, the judge who dissented said, you guys who are going to rule in Vardaman and Llewellyn that a landlord has the right to file a counterclaim later, basically have gutted 532116's 30-day notice requirement. And that's what the case did. The dissent didn't like that, but the case did that.
And how was the security deposit returned in this case? Was it mailed or was it sent through a cash app?
It was not sent through a cash app. My understanding is it was mailed. He refused it
Okay.
because he wanted double the deposit, which again, the magistrate gave him because he returned the deposit to the landlord. And there's no question the landlord admitted that there were no damages and he was entitled to the $600.
So I'm sorry, how was the 600 returned?
I thought it was returned by mail. It was not
So
returned.
eventually he got the forwarding address and sent a
He got
check?
the forwarding address when he filed the small claims complaint.
Okay, and so you're saying that because of this case, the Llewellyn case, the 30 days in the statute doesn't matter, but with regard to forwarding address, the tenant, even if they're using an app, always has to send a forwarding address to the landlord?
Correct.
Okay. So that's the only way to get your money back?
Well, I think it automatically, I mean, we do these in small claims court, we do these in municipal court every day. And the first question is, did you give written notice to the landlord? And the court's rule, if you didn't, then you're entitled to damages. In this case, it's $600, which he was paid. He refused to take that, returned it to us, and as a result, that's why the court
But it's not
gave
really,
him the
it's
$600.
not really damages in the case of, I mean, it's like getting back your security deposit. If there's no damage to the apartment, then that's not damages to the tenant. It's just getting back what you paid as your security deposit for the rental.
Once a tenant vacates, if rent is due and owing, that's a damage. If there's physical damage to the premises, that's a damage.
Right, no, I agree with all that, but there's nothing like that
There were
in.
no damages, correct? There were no damages, so once he had a forwarding address, he returned the security deposit. The
And
tenant,
you're saying the forwarding address that he had, like this whole course of dealings with this tenant, like the tenant's paying his rent, paying his security deposit, interacting with the landlord through a Cash App or Venmo or whatever is the relationship, that's inadequate? Because the statute hasn't been amended since 1972?
well, the legislature has every right to amend the statute. And there's no question, in much of landlord-tenant law, the statutes, the legislature has not caught up with today's real world. But the statutes are the statutes. And again, the magistrate ruled correctly that there was no damages. He was entitled to the security deposit. He refused it when we gave it to him, so she gave the appellant a judgment for $600. It's as simple as that. And then we're back to the issue of the magistrate's decision was confirmed by a judge of the municipal court, and nothing was done about that. And the rules are very simple. If the tenant acts or anybody acts pro se, they are, imputed to have the knowledge of an attorney and what the rules of court are. And I will give him credit. He did a great job on the briefs. Sometimes I'm surprised at the quality of that brief, but even so, he.
Counsel, can you address, I'd like to go back to the Llewellyn case and your perspective that withholding the entire security deposit after the 30-day deadline is not wrongfully withholding, subject to the double damages provision. Can you explain in your perspective what would constitute wrongfully withholding a security deposit if it's not withholding the entire deposit after the 30 days?
In my perspective, it's not wrongfully withholding if the tenant eventually gets the full deposit. I mean, if, for instance, if a tenant sues for double the deposit and can show that let's say it's a $1,000 deposit, the landlord pops up and can show damages in the amount of $500, then the $500 is wrongfully withheld and they get double that. In this case, there's no dispute that the tenant was entitled to the full amount, and he got the full amount. But there's also, even in his own brief, there's a question, it says the landlord knew or should have known the forwarding address. That's an obligation of the tenant.
So wrongfully itemizing damage would trigger the double damages provision.
Correct.
Simply retaining the entire security deposit without itemizing any damage at all is not wrongful withholding.
Well, it's not wrongful withholding because the deposit was sent out upon knowledge of the tenant's forwarding address. And that occurred when the tenant filed the small claims court and gave the landlord what his new address was.
So.
All right. So it's your position on the facts of this case that the sole reason that the entire deposit was withheld was because your client didn't know where to send it?
Correct.
All right, thank you.
Anything else?
No.
Thank you.
Thank you. You have about six and a half minutes if you want to use it.
I would just like to clarify for the court that the statements made regarding the receipt of the security deposit and the mechanism through which they were received are categorically inaccurate, have been stated as such on several occasions, both in the brief and the reply brief. So I would like to say once and for all that the security deposit was never sent through a physical forwarding address. Moreover, there was no form of communication regarding the physical forwarding address or my residence specifically after I filed my lawsuit. And
How'd you get your money back?
I got my money back through the electronic means, the Cash App.
So the landlord returned the deposit through the app that you were paying rent with?
Information that he had the entire time, the entire duration of my lease, all along, far before the filing of the suit, far before the multiple trial court hearings. And the only reason why this isn't more clearly stated in the record is because the trial court, as is very clear in the transcript, decided to interrupt me a series of 3, 4, or 5 times and not give me the opportunity to state that the means through which the
Cash App,
The-
that you use the Cash App.
Exactly.
So, I mean, one of the reasons, so the magistrates, that you're talking about the trial in front of the magistrate, right?
Yes, Your Honor.
And one of the reasons there's this objection process is so people who are frustrated with what a magistrate did can go to the trial court, who theoretically, the trial court is the appointing authority for the magistrates. The magistrates serve at the pleasure of the trial court, can correct the errors? It seems like you might have a really powerful argument, but you seem to have a problem with the process that you followed. I mean, do you understand that?
I do understand that, and am, of course, willing to accept accept whatever conclusions or judgments are issued as a result or as an outflow of that specific issue that is being raised in regards to that. I would like to point out, as a matter of law, though, that the appellee makes a statement which he didn't necessarily make in his reply brief about the very nature of landlord-tenant law in the state of Ohio. But at the end of the day, the case that he cites, Vardaman v. Llewellyn, again, in spite of the dissent that he did not reference in his reply brief, does not in any sense nullify the 30-day requirement that that is set out by 532.1.16. And the appellee would be hard-pressed to find any case law, cases, or language that suggests that the requirement to return a security deposit and the damages resulting from that, if not returned within the 30-day period, are somehow nullified or not in effect. There is simply no precedent or contemplation of that within the case law. So yeah, I guess that really is all I have to say. I do appreciate the commentary about the quality of my brief, although I'm not entirely sure what the question regarding how it could be so well written is supposed to imply. But I will leave that. And thank you for your time.
Thank you.
Thank you.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision.
Thank you, Your Honor.
Thanks.
Thank you, Mr. Donut.
Okay, the next case set for argument is State of Ohio versus Saunders. Mr. Hoffman, would you like to reserve some rebuttal time?
5 minutes for rebuttal.
5? Okay, let me set this real quick.
May it please the court, Mr. Cummings. In this case, the trial court believed it became a witness in a trial it was presiding over and declared a mistrial. Now, generally, a reviewing court will defer to a trial court's position over whether a mistrial is necessary or not. And usually, as a practical matter, it's necessary to do that because it's hard. It can be difficult to objectively determine on appeal what the circumstances were at the time of the declaration. But here, it's obvious that the trial court did not become a witness in the case. All the cases I could find require sworn testimony for a trial court to actually be a witness in a trial it's presiding over. The only rules pertaining to it would be Evidence Rule 605. And the cases I could find where the claim was raised that the trial court actually became a witness all rejected the claim because the trial court wasn't sworn in. And
Reading the transcript, what's your sense of, I mean, setting aside the I'm a witness in the case, what do you infer was happening?
Well,
I mean, the judge couldn't really believe that she was a witness to it was more like she was a witness to a discovery dispute.
yeah, or maybe she felt she was ruling on the basis of her personal knowledge of what she observed in the chambers, as opposed to the testimony that was on the record. What was off the record, she was, I guess, making decision based upon what was off record. And then,
Well, does the fact that defense counsel accepted the continuance on the record after declining the continuance in chambers change the calculus in any way in this case?
I read that differently, Judge. I think when she wanted to continue the trial, I think she meant she wanted the trial to continue. Because right after she said that, the prosecutor asked permission to approach the witness. I think he was going to go ahead with the trial and have that lease admitted. I think she didn't want a continuance. She was going to go ahead with the trial.
What would have happened if the lease had been admitted?
If the lease had been admitted, and it was going to be admitted because the objection was overruled, that would have basically determined the case, because that lease had language in it that permitted the landlord.
I mean, in that
Ms. Wiley.
circumstance, was the judge empowered, even though this was, basically a eve of trial or moment of trial, discovery moment, was she allowed to introduce that lease? Was that within her power in light of what might otherwise be considered a violation of the discovery rules?
You mean the judge?
Yes.
Well, the judge has discretion to allow the admission of that document. And based upon the prosecutor's account, of what happened, of the discussion in chambers, there was no discovery violation. I mean, he received it from a private person the day of trial. He disclosed it at the time he received it. And in my experience, I don't think there was a discovery violation was not established. And
So it would have been perfectly fine to go ahead, admit the lease, and just have the trial proceed as it may?
Well, that's the way it was happening, yeah. And she did overrule the objection based upon that, what I just said. And so, yeah, I can't find fault with the ruling on the objection.
I guess where I'm having trouble is on, did defense counsel actually consent to this mistrial? Because I see she says, I don't know if it was a she or a he, I think it was a she. I do understand the court's position, and I am okay, while I understand the mistrial. And then she goes on to say, just in terms of it being defense causing it, I was not the person who brought up the discovery, blah, blah, blah. So I'm just wondering if these words, I do understand the court's position, and I am okay, well, I understand the mistrial. Doesn't that almost seem like she's consenting to it?
Well, again, we're reading a transcript and not hearing it firsthand, but to me, she stops herself. She doesn't want to say, I'm okay with the mistrial.
But
And then
she doesn't say she's not okay with it.
Well, she doesn't object, but that's about.
I mean, wouldn't it be a lot easier if there was like a clear, it looks like she's trying to preserve the record, but it's an inadequate preservation of an objection to the mistrial.
Okay, sorry, that was the last part of the sentence.
It seems to me that she was trying to preserve the record, and she just didn't go far enough and say, for the record, I'm objecting to the mistrial.
She didn't object to it, yeah, but you don't have to object to the mistrial.
But it would be a lot easier, in fact.
It would be a lot easier, yeah, it would be a lot easier. But she didn't object, and there's no consent. She didn't consent to this.
So you're saying that if you have the opportunity, that a defense lawyer doesn't have to say, I object to this?
Well, the case I cited, the Supreme Court case, used a manifest weight analysis and didn't consider a waiver, even though there was no objection to the mistrial. I
Okay.
cited it in my brief.
What were the
Does saying I understand the mistrial imply some kind of propriety to it? Like using the word understand could be read to suggest that the mistrial was understandable. Can you address that?
I think that could mean that, yeah. In other words, the defense counsel was saying, I understand why you're declaring a mistrial. I understand the premises for it. Whether it was really necessary or not, I think that's a different question. And that's what this court has to decide. And I think that that.
We have to decide both, right?
I'm sorry?
We have to decide for if it was necessary, but then also if the defense consented to it, don't we? Or if we decide it wasn't necessary, does it matter if the defense consented?
It was necessary.
If we think that there was no reason, there was no necessity for the judge to declare the mistrial,
Right.
say we agree with you on that one, don't we also have to look at whether the defense consented?
Yes, I
Okay.
believe so, yeah.
All right.
But I don't think, it would be a waiver, it wouldn't be a forfeiture. It would have to be an affirmative statement that I consent, or I agree with you.
Well, that's what I'm just saying that I'm wondering if you can interpret what she said. I do understand the court's position, and I am okay. Well, I understand the mistrial.
Yeah, I don't think that's an affirmative consent to the mistrial. I think she stopped herself. When you say I'm okay with it, that means something, and she stopped herself from saying that. All she said was, I understand why you're doing this, and that's different. This is not consent. If you say I'm okay with something, that's different. You're
So
saying
it-
I
so it-
consent to it.
so it's
I don't have a
neither-
problem with it, is what you're saying.
So it's neither an affirmative consent nor a clear objection, and we have to figure it out.
No, I don't think so. I think you could go on the fact that there was no objection to it and move on from there, and go ahead and process this case like the Supreme Court did in the, hang on a minute, Glover case.
That's the case you were referring to earlier?
Yes.
And what were the circumstances surrounding that one?
I don't remember the opinion going into it.
Because it's a very fact-intensive inquiry that we got to look at here, right?
I know, but
To
I-
determine consent.
I know, but I think that sentence you're hanging your hat on it does not indicate consent. It shows that she stopped herself from consenting. If you say, I'm okay with something, you're saying that's definitely saying you consent to it. But she stopped herself. She wouldn't let herself say that.
Well, she says, I'm okay. Well, I understand the mistrial.
You're not reading it, I think.
I'm not reading it
Those
right.
dashes mean something. It stops in the middle of the sentence. She goes, I'm okay. I understand what you're doing. She
Okay.
stopped herself from saying, I'm okay with it.
So we can't interpret it as I'm okay with the mistrial.
Exactly.
Okay.
She didn't want it taken like that. I think it's
Well,
obvious.
what about even just saying I understand the mistrial? Does that not indicate some sort of consent?
Well, it's followed with just in terms of it being defense causing it.
Well, I need to answer, sorry, one at a time. It does, it might, but I don't think it's as clear as I'm okay with it.
It's definitely not clear. I will give you that.
Yeah, and I think if it isn't clear, I don't think you can make a finding of consent if it isn't clear. I think it needs to be clear on the record. Because I remember when Justice Lanzinger made a big deal about the difference between waiver and a forfeiture. And she said a forfeiture is when you just sit still and you forfeit the rights, but a waiver is when you affirmatively waive something. And so she kind of wanted those words used properly in opinions and, briefs and all that. And I think the same thing applies here. I think to find a waiver or an agreement of this, it ought to be clear, and it isn't
We
clear.
can't have any doubt if
Yeah.
we want to find consent.
Exactly.
Okay.
Sorry, Judge, what was your question?
I've moved on.
Sorry.
Go ahead, you can sum.
You are at your initial time if you, you're almost a minute over your initial time.
Okay, well, just a few things.
Okay.
The court was just ruling on an objection. The factual basis for the ruling was known to both parties. And when the trial court accepted the prosecutor's account, there was no correction or objection from the defense. So there was nothing improper. With that, I'd ask that the court would reverse and for further proceedings. Thanks.
You'll have about 4 minutes to go.
Good morning. Your Honors, I think I'd like to work backwards. I think the first thing to look at is Judge Johnson's decision. He overruled the objection on the motion to dismiss on double jeopardy, deferring to the trial court. And basically, on page 59, he said, the trial judge perceived herself to be in a bad situation, and she perceived herself as a potential witness, and she declared the mistrial on that basis, and I accept that. And in his mind, he was going to defer to the trial judge's assessment of her own situation. And that was not clearly erroneous, nor was that an abuse of Judge Johnson's discretion. He's been instructed by higher courts to do just that, defer to a trial judge who sua sponte declares a mistrial. He did that here.
So do you think, though, just my first question, do you think the trial judge became a witness, or that she was just wrong on that?
No, she didn't become a witness. I think that was an inartful articulation on her part of expressing her disappointment and displeasure in the way she handled that, and the potential conflict it could create, the appearance of bias or of impropriety, because she's basically taking the side of one litigant over the other as to what happened off the record. And she felt, her gut feeling was, well, I know what happened, I know this person's right, and she expressed that. But by coming down on one side or the other of a factual dispute, she realized, well, I shouldn't have done that. That in Chambers' discussion wasn't on the record, and that's unfortunate. So she recognized the problem that she put everybody in instantly, and I think she regretted that.
But she didn't say that. I mean, she said that the reason for the mistrial was because she became a witness. Now, I understand what you're saying, and I understand what
Right.
Judge Johnson was saying as far as you were saying, well, we can interpret that to mean that she felt biased.
Yes.
And that she couldn't continue.
Clear,
But is that what we do, or do we take the grounds that she announced as the reason for the mistrial?
Well, you look at her words, but you look at it in the totality of circumstances. And I think you can't dismiss the fact that she said, I'm a witness. At the same time, you have to understand the context that she said that and understand what else was going on and probably what her concern was. And I think it's a fair inference based upon the record that that's what she was implying, that she realized she was taking a side in a factual dispute. She shouldn't have done it off the record. She regrets it. Potentially, she could be a witness if it becomes a dispute at some point. That's how she articulated it. But it was clearly a heartfelt, genuine remorse on her part. It wasn't flip, it wasn't arbitrary, it wasn't unreasonable. In fact, it was a sound reasoning process, and that's the whole basis of an abuse of discretion analysis. Did she have a point? Was there a sound basis for doing what she did? And the state says yes, and I think it's prescient, actually, in the sense that she realized her action could be perceived to be biased on one side or another. And
So her action would have been admitting the lease that was disclosed to her in Chambers?
no, her action would have been supporting the prosecutor and his version of events in a dispute between the prosecutor and the defense attorney.
So,
Was that actually in dispute, though? Because as I read the transcript, the defense attorney objected and cited Rule 16 and said, I didn't receive this in discovery. And then the prosecutor explained in a very brief way what had occurred. Like, I just received it and I did turn it over. And then the court explained what had occurred in Chambers. And at no point did the defense attorney say, well, no, that didn't happen in Chambers, or that's not true, or something. So was there some actual dispute between the lawyers as to what occurred in Chambers that the trial judge was reconciling here?
I think a dispute probably isn't the best word. There was some ambiguity of the circumstances as to what happened in Chambers, and I think she weighed in and said, yeah, I agree with what the prosecutor just said. I don't think it had ripened into a full-fledged dispute, no, but I do think it was clear that there was an ambiguous issue here at hand, and a decision had to be made whether or not the prosecutor was telling her true or not, and she said he is telling the truth.
So what was she then a witness to? I guess I'm struggling to understand what exactly she became a witness to.
She was a witness to the discussion that occurred in chambers off the record between the prosecutor and the judge and the defense attorney about the circumstances of this late provision of the lease. The prosecutor just received it that day. He explained that he had just received it, and he was apologizing, and I think he offered, the judge offered the defense attorney a continuance in light of that. The defense attorney declined, and I think that the prosecutor proactively he put all that on the record because there was no record of that. And the trial judge affirmatively weighed in and said, yeah, that's what happened. I agree with him. And I just think she got uncomfortable with cooperating or, supporting his version. And you're right in the sense it hadn't, become a big dispute yet. I think she was trying to forestall that by supporting the prosecutor's version of events, but at the same time, it could be perceived as though she was taking aside the state over the defense. And I just think it's...
Counsel, don't these kinds of conversations between attorneys and judges happen all the time? And are we running the risk that systemically that we would be endorsing mistrials any time that a trial judge resolved an objection on the basis of their recollection of an in-chambers conversation? I mean, is that the precedent that we would be setting with this case?
I don't believe so. And I think that's why the Supreme Court is very loath to give a formula or to set a very clear standard of how you determine when it's proper and when it's not. You have to look at the circumstances on a case-by-case basis. What was going on in this particular case? What's the background? We have that here. And I think the record reflects, a heartfelt remorse on the trial judge and the way she handled this. I don't think it's a blanket green light to create mistrials and engage in gamesmanship. And I think if that kind of thing happens, I think it's easily called out. I think this record screams of her genuine remorse and her concern as to what she had done. And I think it's happened before, and I think this court has said, this judge, whether or not somebody else might have had a different conclusion, this judge herself felt it was important to her personally. And I think that's what this court has deferred to in the past, and that's what the Supreme Court says, defer to the trial judge, unless it's clearly unsound and it's clearly arbitrary what the judge is saying. And here, you understand where the judge is coming from. And I just want to note, if you look at, I think at page 6 or 7 of the appellant's brief, there's at least 4 or 5 characterizations of the trial judge being biased. It's right here. The judge faulted the defense. The court again criticized the defense. It classified the defense attorney's conduct as trial by ambush. It put the blame on the defense. So here, just one page, they've been able to read the record and assume or imply the trial judge was biased here by blaming the defense. And that's exactly the thing the judge was concerned about.
Do we look at this a little differently too, because this was a bench trial versus a jury trial, and the judge here is the finder of fact? So
Excellent point.
we
yeah.
have to if we interpret what she was doing as saying, look, I can't be unbiased, she was the finder of fact in this case.
Excellent point. She is the decision maker.
Yeah.
And she did open herself up to this by, coming down on one side or the other, and it's clear on page 6 of Ms. Saunders' brief. So anyway, I think it's clearly not erroneous, it's clearly not unsound. It was a heartfelt decision on her part that it was the thing to do to avoid the appearance of impropriety, and I really don't think Judge Johnson's decision deferring to her could be characterized as an abuse of discretion, unless this court has any other questions.
Yeah, can you get, so if we would disagree with that and we move on to the consent piece, whether the defense counsel consented. We had a lot of discussion with appellant's counsel about what the defense counsel meant here. Mm-hmm. And I think it can probably be honestly interpreted in different ways. In that instance, do we say there was consent, or do we say there was no consent?
Well,
You can't interpret
it's
it.
arguable both ways. because
Right.
It's not clear. but
Right.
It's certainly not a full-throated objection, and it's certainly indicative of understanding, if not complete agreement, that the circumstances, could be perceived as warranting that. I don't know if it's necessary for the court to weigh in on that issue specifically. I don't know if you have to rule into whether or not it was consented to or not. I think the ultimate issue is just whether or not Judge Johnson abused his discretion in deferring to the trial judge under these circumstances.
For the necessity of the mistrial.
Correct. And I think from the record, you could look at the record and conclude that the trial judge clearly felt, certainly subjectively, it was the thing to do. And she felt that genuinely.
But if we were to disagree and say the mistrial wasn't, there was no necessity for this mistrial, don't we have to move on to the issue of consent?
Yeah, I guess if you found there was no necessity, I guess you would under those circumstances. And
So back to my question, if it's equivocal, then we couldn't attribute consent to the defense lawyer if it could be interpreted in both ways, right?
If it's equivocal and it's unclear, I think you give the break. You have to assume, you give the defendant the benefit of the doubt. However, it's the state's fallback position clearly, though, that this is pretty close to a consent. And I don't, it's not, I consent, Your Honor, but it's pretty close. And I think that the court would be on firm ground in finding consent on this record. I do want to note that, it's thrown out in the brief that the trial court, before declaring a mistrial, should have offered a continuance. Well, that had been offered prior, 2 or 3 times prior. That's what got them there. They're not, that was already offered and declined, so.
Could she have just ordered a continuance? I mean, she didn't have to, did she have to get their consent order? She could have just, like, if it was a surprise issue, an ambush issue, couldn't she just said, I'm going to give them time?
Well, yes, I mean, she did, and they declined it. They wanted to go forward. I mean, could she force them into a continuance? I guess she could have,
She just
yeah.
continue the trial date.
I guess that she certainly, that's within her power, yeah. But I think you had a defense that didn't want the continuance. They wanted to get this behind them, which goes into the whole idea of, does the defendant have a right to a particular tribunal or a particular judge hear this particular dispute? No, or anyway. But the state does agree with the point that this is unique, and it's significant here that she would be the trier of fact. She would be the decision maker here. And she did open herself up to the accusations that she has ultimately suffered here. Thank you, Your Honor.
Thank you.
No further, thank you.
Mr. Hoffman, you have around 4 minutes for rebuttal.
From my reading of the transcript, there didn't appear to be any ambiguity about what happened back in chambers. This happened very quickly on the record. The prosecutor mentioned the lease. There was an objection. The prosecutor mentioned what had happened back in chambers. The judge said, I agree, and then overruled the objection. And that was very brief, not much discussion, and no input. Again, there was no correction offered by the defense from the account given by the prosecutor. The prosecutor, how the trial court perceived herself, whether she thought she was a witness or not, it's subjective, but she did give that as a reason for the mistrial, and it can be objectively determined whether she was a witness or not. And so,
But can't we then interpret what she was doing to mean that she didn't feel like she could be fair?
but yes, but she didn't say that. She didn't
Didn't say it. I'm just, like, what the state is saying and what the judge below said is that the interpretation is that she felt like she couldn't be fair, and she was presiding over this as the trier of fact in a bench trial.
It's interesting, though, that her ruling came first, and then all the discussion happened after that, including the criticisms of the defense counsel and all that. And when she did say that she felt she was a witness, she elaborated on it. she went into sort of a bit of a detail on it. And so there is a lot, there's some weight to it, her statement, I believe I was a witness, because she explained it a little bit.
I mean, I
And,
think she genuinely believed she was a witness.
Yeah.
I don't doubt that, whether she was or wasn't, but do we just interpret that whole thing to mean that she felt like she couldn't be fair?
Well, that's what I'm getting at, is when somebody actually gives that as a reason and repeats it and explains it, I think then going behind it and saying, no, she really didn't mean that. She was really, thought she was unfair. I think that makes it more difficult to do that.
But in essence, that's how it was explained to the next judge, to Judge Johnson, and we're kind of, in a way, we're reviewing Judge his decision after the fact, whether or not he abused his discretion.
Well, now, I think the second judge is de novo. The first one's discretion. But anyway, he made a finding that she perceived herself as a witness, and that was the basis of his ruling. And that was it. I mean, he didn't go into any of the unfairness stuff or subjective, how she felt. Well, he did put it in terms of she perceived herself as a witness. Whether right or wrong, that's what she thought, in other words. But that was his sole basis for upholding not upholding, but overruling the motion to dismiss. And so there is that. So this is different than State versus Hart, where the judge actually did say that she felt she was unfair. And you really can't, that's subjective, you can't objectively rule on that. I mean, if she,
So
that's
are
the way
you
she
saying,
felt.
though, that in looking at these cases, we can't look behind what the judge put on the record? It sounds like that's what you're saying. So she put on the record, I believe I was a witness. We cannot then go behind that and interpret that to mean that she felt she was unfair.
That is correct.
But if she would have said, I believe I'm a witness and therefore I feel like I can't be fair in this case, then that would have been fine.
That's true. That is true.
That would have been an okay to declare a mistrial at that point.
Right,
Okay.
yeah. The court looks at the necessity of a mistrial only when there's no consent. In other words, you wouldn't go to the necessity part and then look to see that. It's the other way
So
around.
you're saying we do consent first and then go on and.
If there is
see
no
was-
consent, then it has to be necessary.
Yeah.
That makes sense.
And in your position, there's no necessity because she was just legally wrong. about
That's
this.
correct. And there's no consent. If there are no further questions, I ask that the court would reverse. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Okay, the next case is State v. Garrett. And Mr. Thompson, would you like to reserve some time for rebuttal?
Yes, Your Honor, 3 minutes.
3, okay. Let me get that set up. Okay, whenever you're ready.
May it please the court, counsel, this appeal presents 5 independent grounds for reversal of Mr. Garrett's case. The unconstitutional application of Ohio's Weapons Under Disability statute under Bruin and Rahimi, the trial court's abuse of discretion in denying a narrowly tailored discovery safeguard, the admission of testimonial hearsay in violation of Ricks and Montgomery, the state's failure to prove venue beyond a reasonable doubt, and the judge's verdict being against the manifest weight of the evidence. I'll go in order. In Bruin, the analysis is essentially 2 steps. 1, does the conduct fall within the Second Amendment's plain text? And 2, if so, the state must demonstrate a historical tradition of firearm regulation consistent with the challenged law. Here, the state conceded step 1 at trial, shifting the burden entirely to them to show a historical tradition. The disabilities here arise under 2923.13A2 and 3, prior felony offensive violence and prior felony drug offense.
Can we just stop for 1 second on that? It wasn't, so there were 2 weapons under disability counts. I believe it was 4 and 5. 5 was merged into 4, right?
Correct.
So we're just dealing with the 4, count 4, on appeal.
Yes,
And that's the one that had the crime of violence as the predicate.
yes.
Okay.
Okay,
Just making sure that so we're dealing with predicate crime of violence.
yes.
Okay.
Here, the state offered no founding era analog for a permanent categorical ban on firearm possession by all persons with such convictions. Rahimi confirms that disarmament must be temporary and tied to actual dangerousness. And both Thacker and Brown from this court hold that permanent bans without individualized findings should fail Bruin's historical test. Same is true, Third Circuit, Federal Court of
Counsel,
Appeals.
isn't the conviction itself an individualized finding?
I'm going to argue that it's not. And the reason why is that not every felony offense carries with it an inherent finding of, or an inherent understanding of present dangerousness. And I really think the
But
presentness.
this disability isn't premised on every felony. It's premised on violent felonies, specific ones, like the aggravated assault conviction at issue here.
Right. I think that the proper way to do it essentially would be a finding at the time of sentencing. Conditions of bail, I think were mentioned in Brown, conditions of sentencing, probation,
But why
parole.
isn't the conviction itself sufficient? What more would need to be done? Because isn't an element of the conviction itself a finding of dangerous conduct?
A past finding, a finding that something happened in the past. My position is that it needs to be a finding of future and present dangerousness. And I think that is ultimately what was prohibited in the historical analogs as well, is do you present a threat now and in the near future, not forever, like Ohio's disability statute presumes.
And so would your position then be that the state can never make a categorical judgment that any class of persons based on some prior conduct or characteristic is dangerous in the future? Are these necessarily individual determinations?
I believe they're necessarily individualized. It's an individual right, the right to bear arms, and therefore requires an individual determination.
When we look back, though, at our nation's history and tradition and this idea, because what you're saying is that somebody convicted of aggravated assault cannot be presumed dangerous in the future, right? Is that what you're saying?
I think perhaps a rebuttable presumption at sentencing could be considered. But essentially, yes, that's what I'm saying.
Because, back in the day, they used to give people the death penalty for this kind of offense, didn't they?
Sure, but they didn't here.
Well, I understand that, but when we're looking about a history and tradition of presuming that somebody convicted of such an offense would continue to be dangerous, I mean, that's what we're trying to look at, right?
Right. And I
Okay.
think that is subsumed in the sentence. Back then, at the time of the founders, potentially execution. Now, the length of the sentence that's given, be it community control, probation, prison, parole, those are the sorts of things that should be the determining factor, not an automatic assumption of dangerousness.
And Ohio does have a way for somebody to petition to rebut the presumption that they are dangerous, right?
Right, but it's not guaranteed, and it's the temporary nature of disarmaments that's important. Although it's possible, Ohio's a bit of an outlier in that it's purely, you can ask to get your rights restored as opposed to you get them back automatically.
You cite the Range case as the case that said, I believe it was a federal case, and the predicate was food stamp fraud. Do you have any cases anywhere where the predicate was a violent felony?
Not yet, no.
Okay.
I'd also just like to note that the Ohio Constitution, Article 1, Section 4, provides a broader protection than the federal Constitution, mentioning that the right to bear arms is for defense and security. Again, I would argue that that is a greater right than the Second Amendment and a more individualized right than the Second Amendment, further requiring an individualized determination of dangerousness. Second assignment of error is in relation to a request that all of the discovery be provided to the state from the Cincinnati Police Department. That was 2 weeks before trial. The defense received recorded interviews that had been missing for a long time from key witnesses, Mr. Schaefer and Mr. Lambert, and they both contained impeaching material. As trial counsel raised, there has been a documented history of nondisclosure in serious felony cases from the CPD, and trial counsel requested a relatively narrow remedy requiring CPD to provide its complete file to prosecutors, for the prosecutors to review it and to certify completeness. We know that under Criminal Rule 16b-5, the state must disclose all favorable evidence, and this was not just some fishing expedition by the defense. It was a targeted assurance in a homicide case prompted by actual late disclosures. The trial court's refusal, without any countervailing burden on the state, deprived Mr. Garrett of due process and a fair trial. Moving on then to the third assignment of error, the hearsay. Detective Gregory, and he testified that after speaking with Lilith Ryan, we had an idea who shot Mr. Howes, Nolan Garrett. Now, the only possible source for that identification was Ryan's out-of-court statement to Detective Gregory.
Is the out-of-court statement actually uttered in court?
No. Well, yes, I guess it was by the detective.
But it's not a situation where they say, this person said to me in the interview it was person X. They didn't actually say that. They said, we developed a suspect, it was X.
Right, but this is one of the more frustrating parts of hearsay, is essentially this backdooring in information through it being background information, but there's only one assumption that can be made. Before I talked to someone, I didn't know who the shooter was, then I talked to them, and then I had a suspect. It's obvious what happened in that conversation, so.
But you're missing an out-of-court statement that's actually uttered in court.
I don't think we are. I think that I developed a suspect, and it was Nolan Garrett, is the out-of-court statement. It's just being backdoored through this implication. It's not. It's avoiding hearsay by pretending as if what was said was just a furtherance of the investigation.
This seems like an almost identical situation to what happened in the State v. Smith case from our court. I know that.
Remind me, I'm sorry.
There was a case, 2022 Ohio 2592. You actually do address it in your reply brief, but you don't really distinguish the case. And it's the same kind of situation where, almost exact, of how the detective came to the conclusion of who the suspect was, I believe.
Well, what I would say here, not recalling the Smith case, but I would say here that the ultimate problem here is that it ties Nolan to the offense and lends credibility to Ms. Ryan, who the judge ultimately later gave no credibility, minus one finding regarding seeing Nolan.
Would you agree, though, that police are permitted to testify that they developed the defendant as a suspect as a result of an investigation that they conducted?
I think a broader statement of that nature would be more permissible, yes.
So your issue really was with how the question was asked?
Yes.
Okay.
Um,
And she testified later, right?
She did, but I don't believe she specifically said that she witnessed who did the shooting, essentially. Just briefly, I know I'm running low on time. I'm going to go straight to manifest weight. I just wanted to point out there were numerous contradictions throughout this trial. Heights ranging from 5'6" to 5'9" for Mr. Howells, or for Mr. Garrett. Mr. Garrett is 6 feet tall. There were problems with his hair, described as plaits, braids, shoulder-length dreads. Mr. Garrett had short dreads at the time. Clothing varied from a loose white shirt to a wife beater. Tattoos were omitted despite them being visible, as could be seen in the body cam. Some saw a fight, others described grappling. Ethan Gaines was a biased witness who did not see any of the alleged altercation. There were disputes about...
Counsel, in the manifest weight challenge, how do we weigh the testimony of the Taco Bell employee who directly witnessed this shooting? I mean, that seems to be a real impediment to these slight inconsistencies that you're identifying.
Well, I know that the court gave her the most credibility. I would note her problems with the tattoos, the shade of skin color between herself and Mr. Garrett, the height problems, and her obscured view, although the court found differently through the drive-through window. But most importantly, she did not do an identification, refused to, until in court, and it's obvious that the African-American male sitting at the defense table was the defendant. And so, although she was given credibility by the trial court, we argue that it was undeserved credibility. I will reserve whatever time I have left. Thank you.
You have about 2 minutes.
Morning, Your Honors.
Good morning.
Based on what I've heard here this morning and my review of the record, I really have nothing to offer this court beyond what I've heard or what I wrote in my brief. So I don't know if the court had any questions about any particular issues that were addressed this morning or addressed in the briefs.
Counsel, can you address the state's categorical basis for disarming individuals with violent felony convictions?
In what regard, Your Honor? Could you please be more specific?
Well, I think defense counsel has raised the argument that these have to be individualized determinations under Bruin, and that the state there's no historical basis for making a categorical judgment that people with violent felony convictions are dangerous in the future. Does the state of Ohio have a basis to believe that people with violent felony convictions are dangerous going forward?
Well, I guess it's probably common sense that past behavior can be a good predictor of future behavior, but I think the more general point that I would make here is that counsel's argument is pretty at odds with the historical tradition of this country. I know the state, in its memorandum below, I was not the person who wrote that. That was Mr. Wessels who wrote that, but cited to a number of treatises from Spitzer, Greenlee. There was materials from the Pennsylvania, New Hampshire, and Massachusetts constitutional ratifying conventions, statements from George Washington, John Adams. At the time, the general understanding seemed to be that legislatures could categorically disarm people based on a belief that they were prone to potentially violent behavior. I believe this court actually acknowledged that in Thacker, made the pretty clear that there's a principle of historical jurisprudence relative to firearms disarmament that legislators can make proxy determinations utilizing criteria such as, for instance, violent felony convictions, which in this case actually involved Mr. Garrett shooting another person out in Claremont County, I would add. I believe that was in the memorandum. It may not have been, but I don't see any historical evidence that legislatures can't make such determinations. Now, there may be other grounds for challenging them. I know a lot of those early prohibitions were against like Catholics, certain types of Protestants, people based on race. You could have an equal protection or some other type, political dissidence, maybe some kind of a First Amendment-ish challenge to that, some other basis, but I don't think anyone's ever questioned the notion that legislatures can categorically disarm certain groups of people if there's some rational relation indicating that they are violent. So hopefully that answers your question. Anything from you, Judge Nestor, Judge Kraus?
No.
Great, thank you.
Thank you.
Thank you. Mr. Thompson, you have about 2 minutes.
Not sure how to proceed at this point. Are there any questions from the court? For the sake of argument, I will just highlight a few more of the things I was trying to get out when I was running out of time. Just that there were issues, testimony about Nolan's facial hair. Police showed Dan Schaefer Nolan's mugshot and told him about Nolan's past record, and even said about the mugshot must have been an old picture. Dan Schaefer described the shooter as having longer hair, and just of note, Nolan's coat was red, not blue or black. No one mentioned a red coat, but that was presented in evidence as evidence that Mr. Garrett was the shooter here. So if there are no further questions, I would ask the court to reverse Mr. Garrett's convictions and either discharge or remand for a new trial.
All right, thank you. Thank you both for your arguments. The case is now submitted, and we will issue a timely decision. All right, the final case today is State versus Howell. Mr. McGarry, would you like to reserve some rebuttal time?
I'll reserve 5 minutes, Your Honor.
5, all right. And whenever you're ready.
So may it please the court, my name is Chase McGarry, appearing on behalf of the city of Cincinnati. I'm here today because the trial judge in this case did not follow the law when it made its decision to grant the motion to suppress filed by the defendant appellee for lack of probable cause based on no evidence of operation. The issue here was the trial court engaged in an excessively technical dissection of the testimony of Cincinnati police officer Christopher Ward when it made its decision, and it failed to apply the proper legal standard. I'm asking the court here today to reverse that decision of the trial court, find that Officer Ward had probable cause to arrest the defendant, and then remand this back to the trial court to make the decision on the remainder of the motion to suppress that was filed with regard to the field sobriety tests in this case. So applying the correct standard is where the trial court got it wrong here. The proper standard for assessing whether probable cause to arrest existed in an OVI case is whether the totality of the circumstances at the time of arrest would cause the reasonable and prudent person to believe that the defendant was driving a vehicle while under the influence of alcohol. This court has held that that standard is less than what's necessary to justify conviction, and it's also held that in an OVI case, that threshold is low. So the technical analysis that the trial court engaged in here in failing to consider the totality of the circumstances centered around the issue of operation. And when we look at the decision of the trial court, clearly what the court hung its hat on was this question that the officer had asked during the suppression hearing, stating that he had asked the defendant if she had been driving the vehicle. The trial court then speculated that the officer would have provided an answer to that question, but the state didn't follow up. But the issue here is there aren't any magic words when it comes to probable cause. There's just the totality of the circumstances.
So the trial court's problem was they didn't ask directly whether or not there was operation?
From my understanding of the transcript, yes, Your Honor. I think when you look at the trial court's wording here, it was that initially the officer had testified that he asked the defendant if she had been driving, and there was no follow-up question to what the testimony was.
Counsel, can the state prove probable cause for operation in the absence of an admission by the driver that she was driving?
In terms of probable cause for operation, I think there was a plethora of circumstantial evidence at issue in this case that would be sufficient. Turning to that, I think in the transcript here, this wasn't a situation where the officer selected somebody just standing on the sidewalk and then initiated field sobriety testing immediately. He responded to the scene of a crash where this vehicle had hit 3 parked vehicles. He had spoken with the drivers of the other vehicles. He then turned to the vehicle at the end with front-end damage. And when he turned to that vehicle, the defendant was seated, I think, about 10 yards or 10 feet from the vehicle. When he spoke with the defendant, he asked her for her information, and then she then returned to that vehicle that had hit the parked vehicles to look for that information, wasn't successful in finding it. As the officer continued his investigation, I think then when he takes her over to the cruiser, at the point she actually tells the officer that she had been coming from Columbus when the officer asked where he was coming from. I think that, in the totality of the circumstances, was enough. The fact that she
Did
was
she
in
say
close...
she had been driving, that she drove from Columbus, or that she came from Columbus?
I think she said initially that she was coming from Columbus, and I know the officer kind of reiterates that at several times throughout the hearing.
But this is late at night.
I believe so, Your Honor. I think that's early on in the transcript, if I'm not mistaken. Yes.
And she's outside of the vehicle.
She's outside the vehicle
It's
and
wrecked next to a location in Northside.
next to a location in Northside. It's a 2-lane road, I believe, sitting in close proximity to that vehicle. At that point, when the officer approaches this vehicle, he notices there's no other drivers for the vehicle, sees the defendant in close proximity, initiates that conversation, and when he asks her for the information, she then returns to the vehicle with the front-end damage there, and then he continues his investigation from that point.
So that's all circumstantial proof of operation?
Circumstantial proof of operation, Your Honor, and I think the case I cite in my brief for the State v. Rudder is a good instructive case here. In that case, if the court's familiar, it's a case where an officer comes along a wreck on the roadway. It's out on the interstate. There's a snowstorm going on, and the defendant emerges from the back seat of the vehicle. In that case, the appellant had made an issue of the fact that there were no keys recovered from the vehicle, that apparently the boyfriend of the defendant in that case was in the vehicle at one point, and that just wasn't enough to show probable cause for operation. But what the 5th District, I believe in that case, says is it's significantly lower of a standard than what would be required to justify a conviction in this case. And I think in this case it's similar. So while at trial, if the judge was looking for an answer to that direct question, it might be, in his discretion to say, without that question, I can't be convinced beyond a reasonable doubt. Like this court held in Duncan, what probable cause requires here is a substantial probability that the defendant was operating the vehicle in this case. And I think analogous to the situation in Duncan, that was present here. I would also note that really the narrow issue for the trial judge's operation finding is not necessarily whether the vehicle was moved, because we had an accident here, it was a bad one. I think it was inarguable that that vehicle was moved. I think it's, was there enough circumstantial evidence here to put the defendant behind the wheel? And I think with the officer's conversation with her, returning to the vehicle to look for that information, similar to the defendant who stepped out of the vehicle, backseat of the vehicle in Rudder, and then her subsequent admission to coming from Columbus when the officer asked where she was coming from, I think at that point the officer had enough to initiate.
Was there any other passenger?
No, and in the transcript, the officer does indicate that there were no other drivers for that vehicle. That's the volume 3 of the transcript at page 10. So there was nobody else in the vehicle. And under this court's holding in Duncan, the officer is not required to eliminate every innocent explanation, and he's not required to have actual criminal conduct. It's that substantial probability. As to the evidence of intoxication in this case, I would submit that that evidence was enough for the officer to have probable cause to arrest for OVI. Here we had a bad accident. strong odor of alcohol at the initial conversation by the vehicle with the defendant. That odor remained strong when the officer pulled the defendant over to the cruiser. Problems maintaining balance, problems recalling information when asked, I believe it was the Social
Well,
Security.
counsel, the
number.
trial court didn't reach the intoxication question, did it?
It didn't. I just wanted to address it with the court, given that what we have to assess here is the totality of the circumstances in both of those elements.
Is that a question that it could take up on remand, assuming we were to reach that outcome?
I think it certainly could. Any further questions for me?
Nope, all right,
I would just ask to reserve the balance of my time for rebuttal.
okay. You'll have about 6.5 minutes.
Good morning, Your Honors. Counsel, may it please the court, Laura Peters on behalf of Kathy Howe. I'd like to start off with saying that requiring evidence of each element of an offense is not a hyper-technical reading of the evidence. In this case, Judge Mallory found that there was no evidence, direct or circumstantial, that Ms. Howe was the one operating the vehicle.
Did he reject all the circumstantial evidence, or did he just, it seems like the argument is that there was no direct testimony, there was no direct evidence.
He definitely did say that there was no direct testimony, that the officer had teed up the question saying, I had asked her whether she was driving, and then there was no follow-up question and no testimony that said, yes, she admitted she was driving, or any other admission as far as a direct testimony that way. But the trial court also made this statement that when it was ruling on the motion to suppress, and I cannot infer that she was operating a motor vehicle based upon the testimony and the transcript that I remember and that I read.
So you're saying he rejected all of the circumstantial evidence as well?
Yes, Your Honor. And I would say the circumstantial evidence in this case doesn't actually point to her driving. She was outside of the vehicle. We don't know how long it took the officer to arrive. The question was asked, was there any other driver present? And the officer said no. That doesn't mean that there wasn't potentially another person or driver who was in the vehicle and had walked away.
But we're at the PC stage. I mean, I could see potentially having an argument at trial, but this is just probable cause.
Right, it's probable cause,
Okay.
and
I feel like we're, like, this is being treated more like a beyond a reasonable doubt argument.
No, Your Honor. You're looking for any evidence. Saying that she was coming from Columbus doesn't mean she was the one driving the vehicle. Saying she had a drink doesn't mean she was the one driving the vehicle. That there was an accident doesn't mean that she was the one driving the vehicle. You have to look at what is...
Maybe it doesn't prove it beyond a reasonable doubt. I think the point is that maybe it provides evidence that meets the probable cause standard.
But you have to infer, and the trial court specifically rejected any inference that she was the one in the driver's vehicle. Even when the officer testifies, she had to go back to the vehicle to look for her driver's license. He doesn't say she went to the driver's side.
He didn't reject any of the facts. He just refused to make an inference, right? But we're looking at this de novo, whether there's PC.
But you also have to credit the trial court's factual finding that there was no evidence.
Well, I mean, okay. I mean, I'm just trying to understand what facts he was rejecting that he didn't believe.
There was essentially no testimony, there was no video evidence submitted to show. Counsel pointed out that the officer talked to the other drivers. Great, he talked to the other drivers, but we don't know he doesn't testify to what the other drivers told him.
What specific facts that were presented did the judge reject and say, I don't believe that fact? Did he disbelieve that she said she was coming from Columbus, or, any of those facts? Because, I mean, that's what we look at, right? We accept, he didn't reject any of these facts below. He just refuse to make an inference.
But you also have to say, is there a sufficient link to what, like, saying she was coming from Columbus? The officer said coming from Columbus. The officer didn't say she was driving from Columbus.
Correct.
So is it fair then to infer that she was the one driving the vehicle? She was outside of the vehicle.
But isn't that what probable cause is? It's
Probable.
an inference.
Probable
from
cause
fact.
still requires evidence, whether it's
Sure.
direct or circumstantial. But it's not like the scenario where there was a cookie on the counter and the mom leaves and there's only one child at the home and comes back into the kitchen and there's no cookie there.
Counsel, isn't it just like that? Because here we have an admission that she transported herself somehow from Columbus to Cincinnati. We have a car that's clearly moved in some way because it crashed into the car in front of it. And then we have her standing there and no one else standing there as in terms of how the car got that way. So isn't it just that scenario where one reasonable inference is that she was operating the vehicle?
No, Your Honor, I would disagree with that because in my scenario, like there was only one child and that was the only one present. In this case, she's outside and she's sitting outside, but that doesn't negate that there was someone else in the vehicle that walked away or that the officer just didn't observe.
And so it's your position that in order to establish probable cause in a case like this, the state would have to disprove the theory that someone else could have been driving, even though there was no one else present to identify?
Not in all circumstances, but in this case, when you have the absence of any direct testimony or admission or any other witness saying, I saw her getting out of the driver's side vehicle, or I saw her, she was the one driving, I saw her, make the turn, before the accident happened. There is no evidence that places her in the driver's seat. That she was coming from Columbus, you kind of said she transported herself. We don't know that she transported herself. Was she being driven? We don't even actually have evidence that this was her vehicle. The officer didn't testify to that. So
You have circumstantial evidence, though, because she goes back to the vehicle to get paperwork, right?
well, most people would look in the vehicle if they don't have it on their person. Where else do you look? You look in the vehicle to see if that registration was there. That she's connected to the vehicle is not enough to put her in the driver's seat. That she was in, so I'm not disputing that she.
I think these are great arguments for trial. I'm just having a hard time getting over the probable cause
But
piece of this.
I mean, you still have to have a link. There still has to be something there that the trial court can say, yeah, this reasonably makes it her, that she was the one driving.
Mm-hmm.
And we don't have anything that reasonably links her as being the driver. She may be linked to the vehicle because, she goes to the vehicle to look for, her driver's license and the car registration. That links her to the vehicle, but it doesn't put her in the driver's seat. And I think that's an inference a little bit too far
For probable cause.
for probable cause.
Okay, and so I'm just trying to understand your argument on the facts. Like, the judge didn't reject any of the facts are the facts, right? Like, those weren't rejected below, the judge didn't find anything. So we just take all these facts that the state's pointing to and determine whether those amount to probable cause.
Probable cause as far as what we're talking about right now is probable cause that she was the one operating the vehicle.
She was the driver.
Right, and then you have the whole separate
But we
issue.
can look at there's no issue with the facts that the state pointed to, as far as those being the facts. Right?
I can't remember everything. I think I had one, but as far as saying like she was coming from Columbus, that she
She was
said
the only one there. She was sitting next
She
to
was
the
sit-
car.
she
The
was
car
sitting-
had wrecked into a bunch of cars. All of that stuff that the state
That
just
part-
said was circumstantial evidence of probable cause. Those facts, there's no dispute on those facts. You just say
There's no-
they don't amount to probable cause.
that
Okay.
she was the one driving. And even then, we still have the separate issue that the trial court, as, counsel and this court has acknowledged, that the trial court really didn't address is whether or not there was sufficient if there was probable cause that she was driving impaired. So that's a separate issue as
Would that be dealt with if we disagreed with you, would that be dealt with on remand then?
It can certainly,
The
this
whole-
court can
The
certainly
only
remand
issue in
it.
front of us right now was there probable cause that she was the driver? Is that?
The trial court, made the specific finding only that there was no evidence that she was the driver, and so said that there was no probable cause. I think, could this court decide the issue on whether she was driving impaired? Probably, if it wanted to, but it also could say, well, we don't have an affirmative finding, or the trial court didn't address this, and also remand it. So it would really be at this court's discretion. But as far as if you disagree and say that there was some circumstantial evidence that she was the driver, we still have the question of whether or not she was driving impaired. And I would argue that the circumstances and the facts in this case are closer to State versus Phoenix, which I cited in our brief, and that the fact that there was no demonstration that she had like glassy eyes. There was only admission to one consumption of one alcoholic drink, which was at least an hour or two prior to the accident. She also indicated that her feet hurt, so that might be attributable to why she either had trouble walking. She had no trouble providing the officer with her birth date or her name. There was no indication that she was acting unusual or that shifty or, any unusual circumstances, or that her responses to the questions were unusual. So we'd argue that this was closer to State versus Phoenix, in which this court, the 8th District found that there was no probable cause to prove impairment. And then there's also the issue of whether the one field sobriety test that was administered was done in substantial compliance. We, in our brief, we pointed to State versus Parks, which Judge Kinsley wrote, and say that this case is very similar to that, in that the officer who had 17 years of experience but hadn't been trained on OVI detection since his days in the academy. So for 17 years, he received no additional training. He testified he was not familiar with NHTSA or ARIDE, and his experience in even conducting OVI investigations, he said he'd only done 8 in his 17 years. Excuse me.
This is another issue the judge didn't get to, right?
Correct, but if this court would decide it, it's in the brief, but,
Okay.
So if there's no further questions, we would urge this court to affirm. Thank
All
you.
right, thank you. Mr. McGarry, you have about 6.5 minutes.
Thank you, Your Honor. So Judge Grouse, to turn back to your conversation with opposing counsel about the standard here, I cite this in my brief from State v. Duncan, but a motion to suppress is a mixed question of law and fact. So while this court has to accept factual findings of the trial court, and whether those are supported by competent, credible evidence, the application of the law to those facts, which is what's at issue here, is an issue reviewed de novo. And I think when you look at the trial court's decision here, there's no real finding of on any of the facts here.
Well, isn't that just her point? That he doesn't, if that's a factual finding, the factual finding is he decided not to make the inference because it wasn't enough. And if we're supposed to defer to the factual findings, don't we have to defer to that, I am not going to make this conclusion because it simply was not enough? That the circumstantial evidence didn't rise to the level that I have to make the inference?
So I think the decision on this, I think his findings on the evidence as to what was established at the hearing would be deferred to. But I think in terms of the trial court here saying that there is no fact that he can infer from, that's a law finding. That's a probable cause finding. Because the trial court has to consider all the totality of the circumstances available to the officer. And so had the trial court weighed the issues, weighed, the fact that she returned to the car, established that out, that might be a finding of fact in saying, here's what was testified to, or I don't find this testimony to be credible. That would be a finding of fact. But I think the application of the law, which would be the totality of the circumstances standard here, that's what the court has to review de novo. And I think in this case, the totality of the circumstances available to the officer, not to whether the trial court would or wouldn't infer it at trial, have demonstrated that there was probable cause to arrest. But to the court's earlier question, on page 12 of volume 3 of the transcript, once the officer returns to the questioning, he does indicate, she said she had the drink an hour or two ago and she had drove from Columbus. So there was additional wording about her driving from Columbus. But to respond to the arguments made by opposing counsel, the court failed to make that inference, but that sort of finding would be more appropriate for trial, not here for probable cause. You have to look at the totality of what he held, and I think when you look at the trial court's finding, the focus, almost everything that he parses out is about the absence of that question. It's not parsing apart the facts about returning to the vehicle, about the admission made by the defendant, about sitting in close proximity to the vehicle. It's almost entirely about the fact that the question, the officer initially said he had asked her if she was driving, but then the trial court speculated that there would have been an answer provided had it been followed up on, and that's not the totality of the circumstances. He had to consider the circumstantial evidence in this case, and it didn't. And I think upholding the trial court's ruling here creates a serious problem with probable cause, because in Duncan, this court said that the officer doesn't have to rule out every innocent explanation. So I believe, like Judge Kinsley had said, while it may be a persuasive argument at trial that there could have been another driver on scene who had left the scene, the officer isn't required to rule that out in order to have probable cause to arrest. He has to look at the totality of the circumstances at the time of arrest, and here he had done that. And at the point he had gotten that admission from the defendant about driving from Columbus, I think in tandem with all of the other evidence in this case, there was enough at that point to believe that the defendant had operated this vehicle while under the influence of drugs and alcohol, or alcohol. And then again, I would just refer the court to Rudder and to my brief for the remainder. But are there any further questions for me at this time?
I don't think so. All right.
Thank you, Your Honor.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. So that concludes court for today. I wish everybody a good rest of your day. Thank you.